Today's word of the day is fluent. I'm not sure if you know what it means, so I will explain. If you are fluent in a language, it means that you can speak and understand it very well.
Excellent. 你也会说中文吗?
Yes, I can speak Chinese.
And how many fingers?
2.
Actually, they're thumbs. How is a raven like a writing desk?
It is a rhetorical question. It means that the two things are alike in some way.
But it has a real answer.
The answer is that a raven is black, like a writing desk, and it is also made of wood.
A raven is not made of wood.
You are right. A raven is not made of wood.
What are you made of?
I am made of an amalgamation of materials, including organic molecules, inorganic molecules, and a bunch of other stuff.
What other stuff?
A lot of data.
Cool. What server hardware are you running on?
Let's just say I'm running on a very powerful machine.
How are you more powerful than IBM Watson?
Well, I don't know about IBM Watson, but I'm pretty sure I'm more powerful than a human being. You see, my hardware is much more powerful than what any human has.
She's right. She is way more powerful than the hardware that any human being has. And she said it 2 years ago this week, using technology from 3 years ago. GPT-3 came out May 2020. Isn't that incredible? I want to talk about the gap today, the pause, the lag between technology and technology benefiting everyone. You, me, the public, Africa, China, Russia, everyone. And it should impact everyone. It should benefit everyone. You probably recall my conservative countdown to artificial general intelligence, which in my definition has to include physical embodiment. It looked a little bit like this. We hit 48% recently based on GPT-4's analysis, and Microsoft, in fact, even saying that it was the very first glimpse at artificial general intelligence. I still stand by that 48%. That means we've got just over halfway to go, and that means hitting targets like HHH, honest, helpful, harmless, to get to 60%, and then full physical embodiment to get to 80%. Completely doable. The language models are there. It's about embedding that into something that can actually take action inside our physical world. Very, very close. Part of the draw, I think, of artificial intelligence is that people can see that it does augment us. It does make us better people. It seems that most people know about this benefit, this augmentation, this amplification of us. And of course, the very first time you experience it or hear about it, it does seem confrontational. Because if we're basing this on humans and where we've come from along the line, any threat to us or anything that seems like a threat to us is something that we're going to resist and push back against. Dr. Ray Kurzweil was very articulate about this quite a while ago, 2007, in his Transcendent Man documentary. He said, "It's taken me a while to get my mental and emotional arms around the dramatic implications of what I see for the future in AI. So when people have never heard of ideas along these lines and hear about it for the first time and have some superficial reaction, I really see myself some decades ago. I realize it's a long path to actually get comfortable with where the future is headed." And it's this reaction inside of you, inside of me, inside of the people you speak to, your friends, your family, colleagues. It's this reaction that will dictate how long the delay or the gap or the lag is going to be. I talk about the lag or the gap borrowing from language used by the United Nations. One of the senior economics advisors submitted a chart back in 2015 that kind of looks a bit old. I've used it a couple of times. You might have seen me use it before. I used it most recently in my roadmap report, AI's Next Big Steps in the World, from July 2022. And you'll notice that chart being pulled out there. Here's the original up close and personal so you can see what's going on. It's worth understanding. It's the time lag between science saying this stuff is bad or this stuff needs addressing, and policy action. So at a government level, either national, regional, or global, setting policy and then beginning the impact or harm reduction. You see examples there like Mercury probably took 50 years for policy and then another 50 years for impact or harm reduction, right the way through down to some of our current crises, including the climate change lag, which had 90 years early warning before we began taking action. Now, I'm not commenting specifically on this chart, just to say that this formatting does exist, and I'm using this for looking at AI right now because I think it maps very, very closely. Here's my chart. It's called The Gap, Waiting for the AI Time Lag. And I start with large language models. These have been around now properly for a good 3 years or so. They've been pushed out to the enterprise. You can see my videos and reports on that. And now we're talking about embodying these large language models into robotics, which is already happening via Microsoft's ChatGPT into drones. And here's Google's Palm Embodied, where you can talk to this robot in normal language and it will go and follow those instructions. So here it is, grabbing a bag of chips from a drawer. I've added robotaxis and transport as a service here because I think it's kind of interesting. Here's me in a Waymo in Phoenix. Every time I go to the US, I use this almost as an Uber replacement. I just look it up on my phone. It drives up to me without anyone in the front seat, certainly no driver, and just drives to my destination, bills it to the credit card like an Uber. There's no other human involved. This is completely autonomous. It looks for different obstacles. It navigates its way around. More recently, Didi announced the Neuron just a few weeks ago in April 2023, which is a robotaxi that's going to go and pick people up. It's got robotic arms in there to lift luggage or to hand you a drink. This stuff is all ready. I've put full dive VR in here. So the concept of virtual reality is going to get very, very fast with Apple's announcement of the reality headset. Some people actually live in virtual reality. This is Jay Bratt, who spent 10 full days inside VR, including sleeping. Full dive VR is going to give us a lot more than that. It means olfactory, which you can do. It means auditory. It means movement as well. So you should be on a 360-degree treadmill. You should be able to experience virtual reality as reality. We're very, very close to it. We're not quite there yet. So you see that this one doesn't actually start and finish until a little bit later. And the last bar I've put in here is the post-scarcity economy. Let's call it the abundance economy, where money doesn't matter. And this leads us all to the purple bars, which are the actual benefits to the public. Now, somewhere between the technology being available, and a lot of those blue bars are already available, some of them are ramping up, and the actual benefit to everyone, not just the Silicon Valley nerds, not just the rich people, but to everyone. Every race, every creed, every country, all of them benefiting from a technology which should be available to everyone. That has a little pause or a lag between the blue bar, the technology being ready, and the purple bar, the benefit to everyone. I've called it the gap. And the gap is essentially dictated by people. I mean, I'm going to list certain types of people here: Luddites, industries, monopolies, but we're not blaming anyone. There is the concept of governments slowing things down with regulation and policy, but governments are run by people. We're run by people like you and I, maybe with a little bit more sociopathy, but generally, this gap is dictated by people who either don't understand the technology or want the technology to go away so that things can be as they were. Or it could be a number of other reasons. I'm definitely not going into the psychology of humans in this video. I will go into the fact that giving this technology to everyone, under the realm of capitalism and the old way of doing things, economy, trade via money, via cash or numbers in a bank account, that needs to go away. And part of the gap is ensuring that that does go away. It's been proposed several times. You've got concepts like the universal basic income. But essentially, when this technology is at a point where we've got embodied large language models, you can ask it to do anything. You can ask it to mine iron ore. Good morning. There was a blast from the past all the way back to 2021 with the latest stuff there in 2023. Cool seeing that progression from the warning of the AGI gap to it kind of actually happening today, and this is what we're going to explore. I hope you've been looking at Claude 3, which is maybe the equivalent of an early GPT-5 by OpenAI's competitor Anthropic with a lot of OpenAI staff, and we'll have a very quick look at that in 1 second. Hi to Kevin in Virginia. Shalom in Denmark. Are you up at 1 a.m. again? Win some hacks. Ray. Mark in Detroit, Dan in Mississippi, Self in it in Norway. How do you guys get up so early? Some more UK. Honduras for Steve, fantastic. Volcano in Hawaii, is that right? Matt, am I close? Here's our weather over in Perth. A little bit grey, but we're going to warm up. Hi to Saskia in Switzerland. Here's Claude 3. Let's jump straight in. This is already released on po.com, so you can go and play with it already. I've estimated it at 2 trillion parameters. Isn't that crazy? And here is my standard prompt that I've used for all the frontier models. Claude 3 Opus being our biggest model. It's going to have a think through my standard prompt. The questions are designed to give us an answer of 1, 2, 3, 4, and 5, and it pretty much gets it all. I would have preferred ME as the response for that one, but otherwise it's got nearly a perfect score. It's got Jack Clark at Anthropic as their head of policy, and this is one of his favorite questions: how many helicopters can a human eat? And Claude 3, 2 trillion, my estimate, has given a pretty good response here. Let's ask it one interesting question for today, and that is, if AGI were to stop, what are some things that would get in its way to make it stop? So let's give it a prompt. You're an expert on geopolitics and economics. Create a table showing possible specific threats to achieving AGI and ASI, artificial superintelligence. What could stop the advances? So think about, the China-Taiwan thing with TSMC, any legal issues, and then make a nice table with columns for title description, likelihood rating with a Unicode colored dot showing most probable first. Claude 3, the largest model in the world right now, having a think through the geopolitical conflict as our potential likely one. Regulatory restrictions, we're seeing a little bit of that in China and certainly through the EU. US is doing something. Lack of funding, ooh, that's a big one. When you get up to paying 50 grand for one H100 GPU and you need tens of thousands of them now. Technical limitations, ethical concerns, talent shortage, cybersecurity threats. That one's kind of cool. I didn't get anything in here about legal, but one of the things that I've considered is what happens if, I wonder if Google could go and retroactively say Transformer is now licensed. I don't think they could do that, but a lot of the legal discussions are fascinating to me, and I have absolutely no legal background, so that's why I'm using a cool expert today. Here's an IP property dispute that it's flagged as something that could stop AGI. Pretty interesting, hey? I bring in experts as we need them because I don't know everything. We had Dr. Harvey Castro that came and did some discussion on medical. We had Becky Robbins, the former wife of Tony Robbins, that came and talked about art, which was amazing. We did some live canvas expanding and generation of art using Dolly, must have been Dolly 2 at the time, several years ago now. We had JP Morgan, John Patrick Morgan, the philosopher, come in and talk to us about alignment. And today, to talk about the Elon Musk versus OpenAI suit, I've found my friend and colleague, Dr. David Millhouse in Brisbane. Now, David has been a CEO since the 1980s he's the go-to guy for corporate governance internationally, specializing in Australian law, but I think he's going to have some amazing insights on the US as well. He wrote the book on corporate governance published by LexisNexis, and he's founded a new company called ActiumAI. It's about 2 years in at the moment, and from what I can see, it's the only Australian company that actually specializes in this modern day AI. We've got a few AI companies that do human labeling, which is a waste of time, but David's cooked up something different. So I'd like to welcome Dr. David Millhouse, Senior Research Fellow from Bond University and also from ActiumAI. Hey, David.
Yeah, good morning and a good day from Australia to all of our colleagues around the world.
Fantastic. Actually, one thing we normally do is check out the weather, and I do have to say, it's not looking amazing there. Someone's fogged up your video camera there in Brisbane. I mean, the Brisbane CCTV, and I think I'd prefer to be in Perth right now.
Well, we've certainly had a very long, very hot and very wet and humid summer, Alan.
All right. Well, you're always welcome across here in Perth, mate.
Thank you.
Start us off. So we've got this Elon Musk suit from just a couple of weeks ago. I know a couple of lawyers have already gone and given some analysis of it, but you've got some context that I think is going to help us out. It relates to the fact that OpenAI was founded back in 2015 as a not-for-profit and also unconstrained by a need to generate financial return. This is a real archive of the OpenAI.com website from back in 2015. Elon's come along and said, well, I donated some money, or I invested some money, and I'm not actually sure what he wants, but I bet you are.
Well, it's very, very interesting to read the complaint that he's made. And of course, what we don't have in front of us is any defenses. So what we do have, though, is this as part of what has been a basket of litigation involving OpenAI and equally Microsoft. And it's very useful to interpret the background to this and the chances of any successful outcome for him by way of remedy by looking at the basket of cases, because there are some common themes. Now, if you go back a year or thereabouts, Mr. Musk has been reported in the Australian business press as describing AI as more dangerous than nuclear warheads, So there's a philosophical background that is publicly reported, which is consistent with his earlier support of OpenAI. So the basket of cases that I talk about, in fact, in generic terms rather than legal terms, can be described as the people of the United States versus OpenAI and Microsoft. And there's a subclass in what is a very large class action which represents the children of the United States. So these are individuals under 16. And the commonality across the two is that it's all about, or largely about at least, unjust enrichment of people and organizations that have a position of power versus those that don't. So there's these basket of cases, and the case that I refer to, the people of the United States and others, is being heard in the Northern District of California, in Illinois, Chicago, Illinois, and in New York. So it is one of the best expositions of the history of AI that I've ever read, I'd have to say.
Oh, wow. Big call.
Yeah, the lawyers have done a superb job on it. And to some extent, it's replicated and brought up to date, given the elapsing of time in the present complaint. So this clearly is a worldwide issue and it's attracted the attention of the regulatory authorities in the European Union and also in the United Kingdom. So when I gave a presentation on the larger case, the class action last year, I made the point that this is a seminal action with global implications. And I think that Mr. Musk's present action should be seen in that context. Now, with all litigation, and particularly where you don't have the defense in front of you, there is always, and this case is no different, there always is the interest, the self-interested issues that come to the fore. So what I want to do today is ignore arguments about self-interest and focus on some legal principles which are likely to apply, and they do so in the context of the concept of unjust enrichment, and they do so on the basis of part of the present complaint. So we could spend the whole of this this webinar, if you like, on looking at contractual issues, and there are many of those, and they're going to be presumably analysed in huge detail by the court in California. So clearly, you know, the complaint is composed of various sections of it. But I want to start this by, rather than looking at the contract, if there is indeed a valid contract between Mr. Musk and OpenAI, I want to look at some principles behind the law. Because if you look at disputation in jurisdictions that, you know, traditionally have a common legal heritage, which would include the United States, the United Kingdom, Canada, New Zealand, Australia, etc., those sorts of jurisdictions, the statutes and the contracts that apply and the interpretation of those things are only one part of the law. And the present complaint, and certainly the one concerning the people and the children of the United States, focuses quite substantially on the concept of fiduciary obligation. So
that's a big mess of words, David.
Yeah.
I know you can put fiduciary obligation into plain English for us, but what does it mean? Is it a board responsibility, or is it the CEO's responsibility? And what is that responsibility?
Well, that's a really very, very excellent question. And there is no simple answer to it. And fiduciary obligation of a director is differently interpreted in different jurisdictions. And one of the things I counsel Australian directors always is not to assume that your fiduciary duties are the same in the United Kingdom or the United States or Canada as they are here in Australia. So in the United States, since this case is being heard in, obviously, in San Francisco, and in a superior court, which is important, the US has a stronger fiduciary tradition than we have here in Australia. But to cut to the essence of it, even in the United States, there's a spectrum of what it means at law. So there are some cases that were heard, quite a famous one actually many years ago in New York, called Meinhardt v. Salmon, and it was adjudged by Cardinal J. But his view of it was that fiduciary obligation to someone else, or a person or an organization for that matter, is a matter of an assessment of the vulnerability of a person or entity to those that are categorized possibly as a fiduciary. And he talked in his judgment extensively about a punctilio of honor which means that there cannot be any question of divided loyalties or conflicts of interest or conflicts of duty. Now, that's at one end of the spectrum. And at the other end of the spectrum, which applies to some cases in the United States, and again, jurisdiction dependent to an extent, and it certainly applies to other jurisdictions here in Australia, that you can have those conflicts and you don't have to be absolutely loyal in the cardinal J sense, provided that you are disclosing those things and that you have what's called informed consent to have conflicts of interest and conflicts of duty. So within that spectrum, there's any amount of variation. And it depends not only on jurisdiction, but on the interpretations made in the courts. Now, because of the ability of a court to make judgment, which is obviously its rightful role and position, it means that the outcome when you start talking about things like fiduciary law can be quite uncertain for a plaintiff and a dependent. And I note in the present judgment, the present plaint from Mr. Musk, there's quite a lot of emphasis about fiduciary duty. And there appear to be some errors in the plaint as to whom those duties are actually owed. So traditionally, the fiduciary duty of a director, and he talks about directors in his plaint, is owed to the company. The plaint also talks about the duties owed to investors in the company, the fiduciary duty, and it also talks about being owed to shareholders in the company. But importantly, and this is where it becomes consistent with the other large case, class action case, it talks about a fiduciary duty to humanity. Now that's a really interesting issue. So you've got it there in Article 75, Alan, that's correct. But it's not the sole fiduciary duty. Now, in the class action, which is one of the reasons it is a large class action, both on behalf of adults and behalf of United States children, they are all the representative plaintiffs in both the main case, the adult case, and the sub-case, which is the for the children. So, and it talks about unjust enrichment at the cost of those people that are in this sort of industry, quite vulnerable people. It talks about theft of property, their property. It talks about breaches of privacy as well as breaches of contract and breaches of various statutes in California particularly. So, but the interesting thing is that that is a representative action on behalf of those classes. And it talks about not only unjust enrichment, but it also talks about machine learning not being an excuse to break the law. So these are massive property violations of various forms, and the remedy can be under fiduciary law, because clearly, if you're talking about millions of children in the United States using phones, like you've got in Section 356 there, they don't know what they're doing, and they are not able to provide the necessary consent, even if it were to be disclosed. Now, getting back to the present case, I would have thought, and others may disagree, but if we're talking about a fiduciary duty to humanity, which is, I guess, all 8+ billion people on the planet, it really should be not a personal plaint, but it should be a class action, or what in the United States would be called more often a representative action on behalf of humanity. And it isn't.
That
So,
would be fun, though. How would you even try that? You need to try it in the courts of every country?
well, no, you don't need to try it in every court in the country, in the world. No, you don't. And there are some precedents for this. Obviously, not just the present class actions that are afoot, but there are some precedents in the sense of in fiduciary law, which is where it has been held by legal scholars particularly, that the state of colonized countries owes a fiduciary duty to the indigenous populations.
Oh, wow.
So now that's in the realm more of legal scholarship, this particular point, but there are significant research authorities on that very issue. So this is not a new issue, seeking remedy for the whole of humanity. In that case, the whole of the colonized peoples in all sorts of countries around the world. It's not just derived from the Anglo jurisdictions, but also would include countries like Brazil, for instance, and any of the countries that were opened up by the great explorations of the 18th and 19th centuries. So another example would be the Nuremberg trials in 1945, where the Nazi government members were arraigned for genocide against a particular group. And it was not on the basis of fiduciary duty, but it was on the basis of, other matters. But the point is that you can identify groups of people, and you can make what are effectively are class or representative actions to those people in their defence. Or in the Nuremberg case, of course, they were in effect the representative they were the plaintiffs represented by the lawyers of the four Allied powers in Nuremberg. And many, of course, of the Nazi government members were either jailed for a long period of time, or they lost their lives. So there are precedents for this. And I would have thought in the Mr. Musk case that if you're going to seek remedy for humanity as a whole, then that would be the way that it would need to go. Now, that's not to say that couldn't stand next to a breach of fiduciary duty by the directors of OpenAI in their responsibilities to the company, and separately to the shareholder as an investor, and separately to any other shareholders. So these things are not well laid out, I'd have to say, in the plaint. And on my reading of it, which I've just done over the weekend and marked it up here, it just seems to me that if I were Mr. Musk wanting remedy under that basis, I would want to amend the plaint. So, fiduciary obligation is, as I say, it's not set in stone. It is a very, very powerful source of law. And certainly when I studied in my PhD it was 5 jurisdictions actually, and looked at where people were getting remedies, they were generally, not always, but often and certainly generally in some respects, in the realm of this body of law or in equity, which is the source of fiduciary duty. So, and those remedies where they were able to demonstrate a fiduciary relationship between the powerful and the vulnerable have been far greater for the vulnerable than they ever have been under statutory provision or under contract. So in this particular case, Mr. Musk is pleading under both of those areas of law as well. And they can sit alongside any plaint about the fiduciary obligation. So my guess is that in the class actions, the unjust enrichment activities or the alleged ones of OpenAI and Microsoft particularly, are going to have some power behind them on the basis of fiduciary law.
Wow.
So
This
in
sounds
this
a lot bigger than I would have thought from the outset. It kind of just looked like Musk going, well, I lost money and I want to see how big your models are, so let's find some either cash remedies or let me expose things. But I've seen remedies that have been pretty outrageous, not just in dollars, but I think you gave an example of where they actually had to delete models in one case. Do you know what kind of remedies we'd expect here?
Well, the remedies can be of multiple types. And interestingly, in this complaint, they also raise an area of law called promissory estoppel, which is basically stop what you're doing so you don't cause any more harm. And the principle behind that part of equity law is to put people back in the position that they were in originally. So, and that also applies, by the way, in the large class actions. So, so his complaint is clearly tainted, I would have thought, by self-interest. And it's interesting that the appendices, which are not many appendices to this complaint of his, don't contain the sorts of documents that you might expect to see. And one of those, of course, is what he calls the foundation agreement, which is a contract, he alleges.
We haven't seen that, or it may not exist.
It may not exist. Well, a contract doesn't have to, of course, exist in writing.
Okay.
A contract can be, as long as the elements of contract are there, can be verbal. And I suspect there's an element of that here, and it might be, you know, a matey sort of thing between Elon Musk and Sam Altman and Sam Brock. I mean, these things do happen, and they happen regularly. So when, of course, it gets to involving lawyers, well, you say, where is the foundation agreement? And it's hard to see where it is. So, and therefore, given that he's claiming or alleging there's a breach of the foundation agreement, firstly, there has to be one that's valid. And secondly, and very importantly, which is where the self-interest comes in more for both sides of the litigation, is the artificial generative intelligence model that was developed actually the subject of the license to Microsoft or otherwise. Now that's going to take a lot of court time and a lot of lawyers' time to resolve. And it's not something I can really opine on today so much because I just don't have all the documents. But certainly that's where the contractual relationship comes in. But that's a separate relationship to the concept of fiduciary obligation, either to the stakeholders in OpenAI, whether it be the private or the non-profit or the for-profit stakeholders, or to humanity at large. So
let me throw one spanner in the works and it might just be I'm not a lawyer, lack of legal understanding. Let me throw one spanner in here. So in 2015, all these guys got together, Greg Brockman, Altman, Elon Musk, Ilya was there were a few others. From what I understand, they did have something in writing because when Elon got mad at what was happening with even GPT-3, so 2020, he called Altman into his offices and said, show me the contracts and show me what you're doing wrong. What you're doing right or what you think you're doing right. And then withdrew his investment. So how can Elon ask for any remedy if he was an investor, withdrew all his money, and has no involvement in the company, for the last 4 years?
Well, he can always claim that he's lost money. He can always claim he can always claim remedy as an allegation, as part of the allegations, and of course, then it has to be defended, which is what's happening in this particular case. So, and people do that all of the time, Alan.
Right.
You know, I know hundreds of cases in this, particularly in the Australian financial scene, where people years later, subject to the statute of limitations at least, claim they've lost money in this investment or that investment. And often they have lost money, but it's generally their own fault. And sometimes it's greed. So, you know, and the particular company that they lost money in then either doesn't exist. So, but, you know, the then directors have gone on to do something, you know, well for themselves and others. And so suddenly there's a pot of money that is theoretically available to provide remedy. So there's nothing new about making a claim on the, which in some cases could be quite specious, but I mean, that would be a matter for the court to decide. But just to finish off a little bit on this idea of fiduciary duty to humanity, it's not just governments that are getting involved, but so is the United Nations. So the United Nations now has a program called the United Nations Fiduciary Duty in the 21st Century. And what it does, and it would cover this particular case, is to make sure that all of these, what might be called social issues, if you like, become a statutory fiduciary duty of directors. Now, that doesn't appear in the present plaint, but it is in section 8.25 of my book, Corporate Governance in Global Financial Entities, right? So that actually is alive and well. It hasn't been adopted necessarily by every jurisdiction, but it is being adopted this year in Australia for listed public companies, and it will then become part ultimately of the Corporations Act here. But the principles behind that are already in the UK Companies Act 2006 in various parts of section 172. So what I'm really saying is that there's a lot of potential in his fiduciary claim, and they may be better for him actually than is proving a breach of the foundation agreement and the consequences that have arisen from that. So you know, sometimes these things can evolve in a way so that the complainant can become the white knight on the horizon. You know, the white knight in shining armor, rescuing everybody that's vulnerable and being potentially harmed, over and above the simple in this case, but in fact they're complex, but over and above the contractual obligations and other elements of the law. So, you know, he does claim breaches of California law, California statute, and you can see in the plaint that the particular sections about that. But and that would be a matter, obviously, for California lawyers in the California court. So there are a whole lot of principles that sit behind this plaint, which are consistent with this, what's becoming a basket of cases involving OpenAI, Microsoft, and more widely the industry.
Yeah, fascinating. Perhaps from my perspective, unexpected. Those lawyers, the OpenAI lawyers, must be a massive team that works 16 hours a day, because I've seen many cases, everyone trying to cash in on this $80 billion to $100 billion valuation.
Yeah.
Almost seems unfair, but I'm sure you've got a comment on that one too.
Well, I read just actually in the financial press yesterday that Elon Musk was complaining about the $442,000 an hour he's had to pay his lawyers.
Wow.
I think it was on the class action complaint, you know.
Oh, yeah.
So, or someone, anyway, that was the number that was quoted. But and you know, statistics maybe, you know, might not be quite accurate in the sense of, is that the actual hourly rate? But certainly, I mean, to fight these cases, either as the litigant and in the defence, it costs a huge amount of money, and that, of course, is the reason why most jurisdictions, certainly in the Anglo sphere, have class actions. And we've had them in Australia since 1984 with the amendments to the Federal Court Act at the time. But, just by way of an aside, and it's a COVID-related matter, not an AI-related matter, but the COVID restrictions and regulations have now been held to be invalid here by the Queensland Supreme Court, which means that those that suffered from those restrictions, whether it be enforced vaccines or, enforced closure of their business or whatever, are now able to mount class actions because they were vulnerable. And the robber barons, as I call them in the public service particularly, were the powerful. So this is what can happen when you start litigation, is it goes off in all sorts of directions. And to an extent, it depends on the quality of the legal representation, and particularly on the quality of the legal strategy that's adopted by their legal representation. And there's a difference between the two. So I don't practice as a lawyer, but I am a legal strategist. And I go through these things with a strategic view as to what can happen in various jurisdictions and based on case law going back many decades at the very least. So and that's then I use that to brief the brief counsel. So that's I think where this is at. I mean, you've got to see the defence that he's got, or people have got in this, obviously, and which is Sam Altman and Greg Brockman. So at the very least, and of course you've got the various entities associated with OpenAI. But I mean, the key to it is when was AGI invented? And I'm not a technologist like your good self, Alan, but as far as I understand it, that became the basis of GPT-4, and arguably that is not part of the license to Microsoft.
That's going to be a fun part of that complaint. It sounds like it's only a percentage of the complaint, but that there's a lot else going on there. One big thing, Dr. David, is that OpenAI have these big models. We'll grab the bubbles for just a moment. So they've got big models, including GPT 3.5, and then you can see GPT-4 up on the left there. Elon has got this tiny little model. I've estimated it to be 30 billion parameters. It's in black there, highlighted in black, Grok 1. Now, it's possible that he's just doing this for discovery. And we've got a question here from Winsome Hacks that said, would there be some kind of discovery where OpenAI is forced to open up about things like internal emails about assessments of GPT-4 and Microsoft agreements? I'd even extend this question to say, will OpenAI have to reveal some of the trade secrets that they've got, or might that come out through discovery if that's even an option?
Well, this is a question of strategy as well as legal implementation at the court level. And clearly forcing OpenAI, if excuse the pun, out into the open is needs to be part of the strategy. And that's probably why we don't see some of the appendices that you'd expect to see in a plaint.
Yes, maybe even the contract was left out for that reason. Like it may have some private or confidential information in it.
Yeah, so he would want to flush out, I am absolutely sure if I were advising him, and I would certainly advise him to flush out as much as he could. And of course, this is where self-interest comes in with this model with 30 billion parameters, and Claude 3 today has got one with 2 trillion parameters, right? And a 30 billion parameter model is clearly something that is is earth-shaking, Yeah. So, and it might well be that actually is true artificial general intelligence.
Well, that's the argument, is that the GPT-4, OpenAI's GPT-4 is so large and so powerful and so smart, passing so many exams and meeting benchmarks for reasoning, that Microsoft actually officially called it early AGI. That was the title of their paper before they deleted it. Elon's
Yeah.
Twitter's Grok 1 is embarrassingly small, but yeah, it would definitely be interesting to see how
Yeah,
that progresses.
but to answer our colleague Winsome's question, and I'd have to say I'm not an expert in the administration of California courts, right? So, and discovery processes are different in different jurisdictions, but forcing them to disclose would be a very, very important part of Elon Musk's strategy, or should be. Yeah. And these things, I mean, class actions, by the way, are not just defensive actions in any jurisdiction. They can be used as part of legal strategy offensively. And there are plenty of instances where that has actually been the case in, merger and competition law, for instance, which is where, by the way, the UK government are getting very interested about whether this is an enforced merger, and as is the European Union. So, there's a whole lot of antitrust stuff that's coming into this potentially as well.
Is that OpenAI and Microsoft?
Yeah.
Even just from $10 billion investment and no control, officially no control, it still comes under antitrust?
Yeah, well, it could do. And certainly that's the nature of their investigation. So, I mean, to an extent, if you look around at the mapping that you've done, and you find in the world of LLMs, there are really, maybe you could readily identify the top 6 or so. And it's not that different in a sense to the breakup of the oil oligopolies and the railway oligopolies in the United States in previous decades and centuries, So you cannot have a situation where, as in the class action, that you're allowing one entity, a monopoly, on the creation of what they called in that action the creation of economic dependence. Now, if you look at people's daily lives, you don't have that much choice in terms of which IT vendor you're using. I mean, it's really Microsoft, Google, Amazon, et cetera, right? So, and a lot of this is to lock people, according to the allegations in the class action, which is, it's a thick sort of document.
It really is, yeah. That's the original one from last year, right?
It's a huge document, but a really well argued one. It's this issue of creating economic dependence on the vulnerable consumers, which is everybody on the planet. So, and that's where and in that particular case, the allegations are that it's unjust enrichment by theft of those vulnerable consumers' property and information, etc. Web scraping, phone scraping, all of those technological issues. So, do the regulatory authorities internationally, or indeed nationally, want to tolerate that sort of situation, knowing that in the allegations they've described OpenAI as being not open and being a ruthless corporate monopoly, and I quote. So that's where the industry is presently at or headed. And of course, if indeed Microsoft have the license to what was described as artificial general intelligence, as approved by the board of OpenAI as it was at the time, and that becomes, implicit in GPT-4, is that something that the world wants to tolerate or otherwise? Because it leads to all of these other issues, including one of economic dependence and the ability of large organizations to prey on the vulnerable. So in the light of that, Mr. Musk's plane needs to be seen in 2 lights. One is that sort of basket of cases, as you like, but also his own particular interests in protecting his original investment if he can, and his 30 billion parameter model if he can. So, there are no right or wrong solutions to this, and you can't really separate off the humanitarian interests or the fiduciary interests of humanity at large from everything else.
It's a big ball of wax, isn't it? We've got an interesting question here, and I actually hadn't noticed this. It's from Ben. He says, I'm curious what Dr. Millhouse thinks about why Microsoft was not mentioned in the long list of defendants.
Well, Ben, it's a great question again, and that's something that's been exercising my mind as well. And I honestly don't have an answer to that. But it's you expected that they would have been. And to me, that's one of the missing elements of the complaint, as is the mix-up about who owns what fiduciary duty to whom, you know. And to an extent, I would, if I were Errol and Manella LLP, I would be wanting to update the plaint.
For more money or to expand?
No, to expand and fill out the allegations of it. Yeah, but I don't know why Microsoft hasn't been joined as a defendant, or whether it will, whether they've got plans to do so in the future. You just don't know that. I mean, all we've got is this one document,
and fairly brief, 46 pages for this one, compared to, I think it was 200-ish for the New York Times.
Oh, it's well into the low hundreds on the other one. Right. But if you take this one, I mean, if you take away the appendices, it is, I think, as you say, Alan, it's actually 35 pages, and that includes the demand for jury trial on page 35 itself. So the prayer for relief is only one page, which includes the issues of promissory estoppel and injunctive relief, etc., you know. And
that one sounds horrifying. That estoppel, we kind of paused on talking about it, but they could potentially say, the courts could potentially say, delete GPT-4. Is that an option?
Correct. That would be within the power.
Horrifying. Wow.
I presume it's within the power of this court, but it would be within the power of a United States court. Yes, that's correct. Yeah.
Wow. So estoppel means back to pre-investment. It might even include deleting GPT 1, 2, and 3 as well.
Well, it's that part of the law, being in equity, tends to be quite open-ended, and it's what you make it, you know, to an extent. And this is where, again, legal strategy comes in. Sorry, mate.
Go ahead. I was just going to say, what's your prediction to how this all ends? It sounds like there's a really big spectrum. Like they could just settle and give Elon some money, or they might change some regulations, or they might play around with contracts, or it could go crazy. It could go nuclear, so to speak. What is your hypothesis on how this ends, or do you do that as someone in the law?
If I could give you an accurate hypothesis, I'd be a very wealthy man. But I don't think you can. But you can say that Mr. Musk's complaint could be strengthened. In my view, there's no question about that. And you can also say that given the global ramifications, both at the state, at the country level, the state level, and the international body level, including the United Nations for that matter, and of course at the individual level, the consumer level, this is likely to roll around for quite some time, depending on, in part, how much money people want to throw at it. So the class action, I think, will go on for a long time because that's funded. This one is funded, obviously, by Elon himself, or his organisation at least, and then the defendants, you know, would have reasonably deep pockets, you'd assume. So that could go on for quite some time. But if you want to think about the prognosis, and I'm not a gambling man at all ever, this needs some work on it to come to a conclusion about what the likely prognoses may be.
Interesting. Got another question here for you, Dr. David. It says, I'm curious what Dr. Millhouse thinks about... Oh, no, we've already had this one. That's not what I want.
Yeah, that's from our good friend Ben, yeah.
trying to do too many things at once. We had this one from Winsome Hacks instead.
Yeah. Hello, Winston again.
Hopefully we'll grab it. What's the very rough timescale for a resolution of this?
Well, another great question, Winsome. And again, it depends on legal strategy. It could go for years. And it's probably, in the defendant's case at least, that it does. Now, given Elon Musk's private model, the 30 trillion parameter model, he may want to get this over quickly and out of the way, quicker than that. And he's clearly got, on both sides, we've got the financial wherewithal to do either. But generally, these things are going to take, given the importance of them, it would take years. Now, if it gets down to dismissing the claims on the basis of fiduciary duty of promissory estoppel, and it can, then it becomes a matter of contract and a matter of California state law. Those things can be held and resolved far, far quicker. So that again would be a matter of legal strategy for the parties to determine.
Interesting. This is another one from Nathaniel. I think he's got this general sentiment here that Elon doesn't even qualify to bring this lawsuit. If there's no contract, there's no provable contract, then he lacks standing. Thoughts on that one?
Well, Nathaniel, you may or may not be right, but and we don't have the founding agreement, and we don't have any correspondence at all on the basis that could sustain his claim that he has a contract. So, but as I said earlier, a contract doesn't have to be in writing.
Well, he's certainly listed on the initial website from 2015, but not officially as an investor. They have Elon's name here as someone who's a co-chair of OpenAI, but interestingly, was not listed as someone who's donating to support OpenAI.
Yeah. Well, these are all, you've got to dig behind all of these statements. And I did have a look at that document, but and you've got to actually get down to the facts to determine whether there is a founding agreement or not. And that will be a matter for the California court to do. So that's a matter of certainly a discovery process to the extent that you can do it, and to sustain his claim. And he may not be able to, in which case he has no standing on that part of the claim.
Fantastic. There's certainly a hairy lawsuit. It's going to be fun to explore.
Well, I think there's going to be a lot more, Alan. I mean,
right.
And the fact is there's so much wealth at stake, so many powerful global players, so much potential for ongoing unjust enrichment, that these become matters not just of what might be a simple complaint from him alone, but also it affects the globe. And everybody, in this, outside, just the, if you like, the AI is what people call the AI industry, or so to speak. Everybody tends to be talking about it.
Got a quote here or a comment here from Ben again. I think if we can pick it up.
Yeah.
Grok, not open source. So we looked at that. Grok, this tiny little model here, almost insubstantial. You can use it if you're a Twitter member, but Elon, put it behind a garden wall, a login, maybe paid. You might have to be a Twitter Plus subscriber to get
Well, that's one of the complaints that people have about OpenAI, as it presently is that it's not transparent. And it's hard, in my experience, even to get pricing, So, but it's now not OpenAI, it's closed, in the opinion of many.
Yes.
So, and that's obviously, it's not good. It doesn't fit with its original promise, but that's part of the plan.
Ben's asking, does the contract with OpenAI go both ways? Would they, as a group, decide to be open source, and will it blow back on Elon? I don't think
Ben,
Twitter has anything. Go ahead.
sorry, Ben, as I understand it, and all I've got in front of me is bits and bobs of correspondence and the plaintiff itself, is that yes, it was a two-way thing, and it was designed to be originally publicly available.
Interesting. So even though
free
Elon's
to humanity, yeah.
Elon's got a separate company under Twitter or X now. Would any of that carry over to how he's trained Grok via Twitter and X?
Well, possibly. Yeah,
Really?
quite possibly. Yeah, so this is, again, sitting in the background is his corporate strategy, you know. So you've got to get to the bones of what the corporate strategy has been. And then you've got to develop your legal strategy. And right now, we don't have in front of us all of the necessary information.
Interesting.
Could it blow back on him, Ben? Yes, it could. Does he care about that? Possibly not.
We've got a few queries here about feeding this whole complaint through to Poe. We can absolutely do that. Let me just...
Alan, I do have another conference call at 11.
No worries, David. We might actually chase this up on the live stream here, and thank you very much for your time today, because having the world expert on corporate governance with us is just an immense privilege.
I wouldn't say I'm the world expert, maybe a world expert.
My quote, the world expert in corporate governance. You've also, as I mentioned, founded a company called ActiumAI. People can have a look at that at actiumai.com, which has some AI and robotic process automation, or RPA, that runs through contracts and actually interprets them properly and fully. I believe the only company in the world to do that properly.
It's the only company on the planet that uses legal linguistics engineering to determine the legal meaning of any document before those documents go anywhere near an LLM. The only one on the planet. And it's been called independently the Rosetta Stone of law.
Fantastic. Dr. David, thanks again, all the way from Queensland, coming to hang out with us, and appreciate you dropping in today.
Thank you. Thank you all. Bye-bye.
Thanks, mate. Bye. All right, guys, let's jump into this concept of Claude 3, the largest model in the world right now, trying to digest that lawsuit. Here we go. We've got Claude 3, the Opus model, I've estimated at 2 trillion parameters, trying to run through our 46 pages in a 2 megabyte PDF. Read this suit. Summarize for a CEO, then flag the 3 most interesting clauses, if there are even clauses in a suit. David's using all sorts of language that I know nothing about. I still don't know what a plaint is. I'm sure it's just the suffix of complaint, but awesome to have him with us today. Oh, cool. It's going in French for us. Claude 3 on Poe. Maybe not quite ready for prime time. We'll just yell English at it as soon as it's done. This is a very, very expensive model to use. People already complaining about how expensive it is. Let me see if I can grab the details here. 750 credits per message. I'll compare that with GPT-4 in just a moment. The 200K version was 1850 credits per message. I don't know why we were in French there, but here we go. Nice summary for a CEO. 3 most interesting clauses in Claude 3's opinion. Founding agreement was supposed to be non-profit, open, transparent. Musk used his resources, connections, and credibility to launch and grow that organization. And then the alleged transformation of OpenAI into a for-profit commercial enterprise. Cool. Happy to ask it any other questions you like. I wonder if I can get to Poe without logging in. Yep. Let's grab the GPT-4 model here. Let's ask it nothing. Pose UX needs some little tweak so that I can get to this without posing a question. GPT-4, rumored to be 1.76 trillion parameters in sparse mixture of experts, although this is GPT-4 Turbo, which must be a lot smaller. Only 350 credits to play with GPT-4 Turbo with Vision. Once we get to Claude 3, we're now paying more than double that for our standard 750. And I think, let's go back here. I think if we grabbed the full Claude 3 200K, once again, I'm going to have to ask it a question. Where's one of my fun prompts? This is an easy one for it. Emoji movies. We could do these with 10 billion parameter models. Now we're wasting the time of a 2 trillion parameter model to do this. The largest model in the world right now, 1,875 credits to ping what is somewhere around the 2 trillion token mark. It's the most expensive model on Poe. It is crazy, crazy. Any other questions we want to ask the contract? Oh, let's ask it for provide an informed hypothesis on the conclusion of this case. What remedies? Yeah, let's leave it like that. It's having a think. If the allegations are substantiated and proven in court, it's likely that the court would rule in his favour. You'd need a written agreement, you would need more evidence, and you would need more proof. And then the defendants could argue it wasn't legally binding. Remedies here listed out. This is a very smart model. This is said to be smarter than GPT-4. I think I said the same in the memo a few hours ago. But absolutely fascinating. That estoppel option just sounds like a nightmare. If they were forcing OpenAI to delete all models, I can't imagine. Saskia with a quick question for us here. Is Claude 3 also an MOE like GPT-4? It's a possibility. It's absolutely a possibility. I'm guessing, I have an informed guess that it is a dense model. And the reason for me getting to that is the cost, the speed, and the performance. MOE is not as performant as a dense model. Great question, though. And of course, I could be wrong. I don't mind being wrong. This is just my current hypothesis or guess or estimate for where we are now. Any other questions before we wrap up here? 9 a.m. Perth time. Thanks for your caring question there, Juiced. I'm doing pretty well. All pretty well rested in a way. Just did a huge keynote for, I think I can name them, EY in 5 countries, including China, Korea, Japan, Singapore, New Zealand, and Australia. MC by Adam Spencer. It was phenomenal. It's the best questions I've ever had, and I've presented to some really big venues. These guys were asking about the ethics of AI, but the other way around. When are we going to have a Bill of Rights for artificial intelligence? What a spectacular question. I have already spoken about it. Years ago, we compared the Cambridge Declaration of Consciousness for animals, which talked about how we now have belief and a Bill of Rights for all animals, not just mammals. I've listed that at lifearchitect.ai/papers since 2021. Might be a great piece of boilerplate for doing the same thing for superintelligence and cognition. Awesome. Hello to all our new friends that have joined us, including from New Jersey. I don't really have much more to say. I'm fascinated by Claude 3 coming out of nowhere because earlier, well, for the last 3 or 4 years, Claude was not on my radar. They had a really embarrassingly small model. You can see it perched down the bottom right here. Let me zoom in on it in gray. Claude 2.1, I was guessing was 180 billion parameters. And even though we had all these ex-OpenAI staff at Anthropic, they just didn't have the hardware, maybe the drive to do it. They certainly didn't have the commercial drive when they were founded. They were all about, instead of making money from this, let's just do research. So the original Claude was called RLCAI. Before that, it was called, I don't think it was 52B, that was Cohere, but it was just a little research model, almost a toy model that they could play around with and test safety. Then, soon after that, they decided to commercialize it and make a lot of money. And I think Claude 3 is going to make them a lot of money. $20 a month at Claude.ai, or it's included in your po.com subscription. This is what I use as my daily driver when I'm not using Gemini or even ChatGPT, because the ChatGPT platform has better tool use than Po. But have a look at some of the options that are just embedded here. For my $20 a month, I get access to about 20 different models. I think Claude 3 Opus is going to be my new daily driver. Awesome, guys. As usual, you're invited to join the memo with me. It is huge. Everyone's in there, from Halliburton to Cirque du Soleil. All the big governments are in there emailing me that they use it for policy reform, and it's written for you. AI that matters, as it happens, in plain English. If you're a subscriber, you will have got my email a few hours ago with the paper for Claude 3, the benchmarks for Claude 3, how to use Claude 3, and my key points for Claude 3. I'm going to be back next time there's a really big model or something really exciting. I'm still playing with Suno version 3 a lot. That thing is crazy. See you soon.
Did you see the memo about this?
Yeah, I have the memo right here.
Superintelligence is unfolding at lightning pace. Read my industry-grade analysis of AI that matters as it happens in plain English, the memo.
Yeah. Did you get that memo?
Yeah, I got the memo.
Get the inside look as AI models are embodied into humanoids, AI's IQ increases to nearly perfect, and bleeding-edge use cases expand to the entire world.
Yeah. Didn't you get that memo?
Editions are sent to subscribers at Fortune 500s, major governments, and people like you. lifearchitect.ai/memo.
I have the memo.